Lords, in the time that remains to me, in order to provide as much assistance as I can to the court, I'm going to give you some references and short points rather than turn up every authority.
Yeah, sure.
But focus in particular and go to the authorities which Lord Panic directly relied upon.
Well, Sunico is obviously.
Sunico I will deal with, of course. But first, before we get to that, is TIARD, which my Lord Panic did go to. That's at PA 8, tab 70. Once that comes up, the court may remember this was a customs case. Some road carriers had incurred customs and duties, and were the Netherlands state to be after them, that's clearly a customs matter. But the Netherlands state was not after them, it was after TIARD, which was an insurance company who had entered into a guarantee of the Road Association's obligations. And the key point which Lord Panic didn't take you to is on page 17, the contextual point. It's absolutely vital to understanding this case. Paragraph 28, which is such a contract, that is a contract of guarantee, creates a new obligation assumed by the guarantor to guarantee the performance of the principal obligation imposed on the debtor. The guarantor does not take the place of the debtor, but guarantees only to pay his debt in accordance with the guarantee conditions. Now, that is central because what was ultimately at stake here was a claim for customs. The point here is the court says voluntarily entering into a contract of guarantee on a free commercial basis creates a new obligation. As they say in the next paragraph, that may well be an accessory obligation, but it's new. It sort of like breaks the chain, if you like, and resets the clock to where you start consideration of whether this is civil commercial. So undoubtedly, going against the Road Association would have been customs, would not have been civil commercial. The creation of the guarantee is a new obligation, and therefore, just like any other guarantee, effectively is where the court ends up, civil commercial. So when you get to the passage relied upon by Lord Panic, which is at the foot of page 19, the analysis which is being talked about, it says this analysis applies, is even if the guarantor may raise pleas in defence which necessitate an investigation into whether the custom debt whose payment the guarantee contract guarantees is owed. The analysis is the one I've just given you, and over the page 42, which is what Lord Panic drew your attention to, he says, in order to determine whether an action falls within the scope of Brussels, only the subject matter of that action must be taken into account. And he sought to rely on that principle. And he says, look, you just look at the action, you don't look at the background, as he put it. And that's a dangerous illusion, because what the court is here saying is the subject matter of this action, it's not the custom debt, it's the debt on the freely entered into commercial guarantee, which is the subject matter of that. That's where the new obligation begins. That's what we look at. If this had been an action on a debt for customs or any other kind of charge like RUFA, well, you do look beyond the fact that it's simply seeking an action to recover the debt. You do look back at the origin of the claim. You do look back at the subject matter. And if that is customs or tax or public charges for public services provided in the exercise of public authority, well, that is very much defining of whether or not this is civil commercial. And that is how that has to be understood. So my submission is that doesn't help my own friend in our context. Again, assuming for present purposes the court would find this is a revenue matter for DICE 3, that is the subject matter of the action. And this principle takes my own friend no.
Well, appreciating that it's dealing with the, as it were, the Brussels point rather than the revenue rule.
Yes.
It might be thought that paragraph 29 assisted Lord Panic on ground 1.
Well,
because I mean, it's making the point that merely because, in relation to a claim which is a civil or commercial claim, or a claim which is not within the revenue rule, the fact that you have to investigate customs regime in the country in question, because, for example, the defendant raises a defence that the primary obligation doesn't arise or whatever. doesn't turn it into something which it isn't.
So I understand the point, but I want to be careful not to get sucked back into
No, I don't want
ground
you to
one.
be sucked
I'll
back into it.
never finish on ground two. But we would say, of course, because it's where do you find it? In this case, contractual obligation. You look at the guarantee, you look at the customs.
Yeah.
In our case, it's tortious liability rather than contractual obligation.
I understand
we would say what characterises that, and that takes you back into is it characterised by being revenue or not? So the answer to the question of ground one is reflected the same. You get the same answer. I'm just going to go no further than tell my lords. Whatever answer you reach on ground one, you reach the same answer on commercial ground two.
That point.
If I go further than that, I'm reopening ground one. I don't think Mr. Planning takes any further support for this solution on ground one than that. It just, let's say, it just reflects whatever conclusion is reached on the ground one. So, well, the next authority I won't turn up because you've seen it. It's Le Suretou. That is the sovereign power characteristic. Armed operations conducted by armed forces. My lords will recall it.
Yeah.
Very similar principles to Masago. When you look back at it, can I direct your attention to paragraphs 38 in particular, 38 to 39, focus on acts which are at the origin of the loss and damage pleaded, and therefore must be regarded as resulting from the exercise of public powers. Again, the focus is on that, where the subject matter from which it arises.
Yeah.
The next case is Apostolides. I'll give you the reference rather than turn it up. It's SRA 5 tab 51. It's in our skirting argument. It doesn't add to the principles I have outlined. What it does do is repeat them. The significance of that is it's the first Grand Chamber decision endorsing the earlier authorities, although I should point out at the time of LTU, that was the then equivalent of the Grand Chamber, just that there wasn't a Grand Chamber existing then. But it endorses LTU, Rufer, Sontag, Tiard, and Le Suretou. All of them get the imprimatur of the Grand Chamber. The next case was Sapir, which Lord Planning does rely on. So I'll turn that one up on the screen, please. That says SAA 2, Supplementary Appellants Authorities 2, tab 12. You also may recall this was the claim for repayment of overpayment of compensation. It was compensation for Nazi abuses in the 1930s. The land had been confiscated. That ultimately came into the hands of a new owner, Land Berlin, who was a public authority, and it sold the property, and some of the proceeds of that sale went as compensation to the victims. Those victims were accidentally overpaid, and the action by Land Berlin against Sapir and others, who were the successors entitled to the person from whom the land had originally been seized, was to recover that overpayment. And the decision was, well, this was a civil stroke commercial matter. My own friend relies on this to say, look, if it's just a claim for an overpayment, despite the fact that this was a compensation scheme, he says, which must have, implicitly he says, must have involved some exercise of public powers, you end up treating this as civil commercial. That is, in my submission, a misanalysis. And I can go to paragraph 36, which is on page 31. So I should start at 34, so you can see the context, but 34 to 36, please. You can see the authorities being referred to in 34, but then what follows at 35, 36 is not a straightforward analysis. Well, this is just seeking, this is seeking to recover something by way of restitution. So that's not the analysis. The analysis, you can see, goes into the fact that public authority owners, such as Land Berlin, were in exactly the same position as private owners, equally liable to pay compensation by virtue of the law, both in principle and in the amount. The emphasis at 35 is on this being a consequence of the provisions of national law in legislation. The administrative procedure is said to be identical whether you have public or private owners. And importantly, like you see at 36, in the last sentence, that owner, whether private or public, does not have any prior right to a decision as regards the determination of the victim's right to restitution. I pause there because at 37 we do come into consideration of the nature of the overpayment and the restitution, but there is no suggestion that that point at 37 is sufficient on its own, i.e. that's the nature of the cause of action. There is consideration with it of the substance behind 35 to 36. And the emphasis I put on this is that no prior right to a decision, because that would be, if there was, an exercise of public powers by the administrative authority, rather than just simply an administrative consequence of the legislation passed by Parliament. There's no assessment as to entitlement. It's simply a formula which is applied. The land was seized, the land was, the compensation is X. There's no form of assessment as there is in our case, where the application is made. You saw Mr. Beale show you the decisions which were being made prior to revocation, a draft decision, right to be heard, a decision, a right of appeal. All we say, underground one, characteristic of an exercise of sovereign powers, but whether that's right or not, whatever the answer to that is, you get the same analysis at EU level. Sunico is the next authority. It's at PA9 tab 77, and of course is the centrepiece of my learned friend's submissions. I don't need time, take any time over the facts, but can I take you first of all to the Advocate General's opinion, just to draw out some key points, starting at paragraph 50, which is on page 13. I'm taking it my lords have already got the point that in this claim, in Sunico, the action was not brought against the tax debtor, a third party, who was not liable for VAT in the UK, not registered, not VAT registered, had no tax relationship. There is a further point here. The connection between the two claims is merely factual in nature and exists exclusively in relation to the amount, the quantum of damages. In response to questions put at the hearing, the UK government submitted that the tax claim against the taxable persons was not affected by any payment of damages by the defendants. Rather, the tax claim would continue to stand even in the event of payment and could be further enforced. It follows that the claim enforced does not serve to replace the amount of tax lost, rather has the aim of remedying an infringement of a legally enforceable right. Now, I make no submissions to you about whether the UK government was right about that or not, but clearly that was the position put before the court and accepted by them. And so they construed the Sunico action as standing entirely independently of the tax claim, and it was not a substitute for the recovery of tax by other means. And that is an immediate contrast with this case, which is being pursued directly against the defendants to recover the money, the tax money refunded to them. And so this is not on all fours. A further point of distinction upon which the court itself put some reliance is in the preceding page, paragraph 44, which was the point relied upon by Lord Pannick as well. The commissioners were not exercising powers going beyond those existing under the rules in bringing a civil claim under ordinary litigation rules, procedural rules. Last four lines of that paragraph, in particular, contrary to customary practice in the exercise of public powers, and especially in tax law, the commissioners cannot itself enforce and execute the claim, but must pursue it through the general courts of law. That's because they had no tax relationship of any kind with these defendants. But again, not our case at all. You've seen those documents that Mr. Beale showed you. Indeed, my clients received similar documents, the three appellants who appeared below and explained their position to the judge. They were served with those documents and told that a claim under the tax powers would follow. They were told they had a right of appeal and indeed exercised it and were continuing to exercise it at the time of the judgment. And there was a route available to the Danish authorities, to SCAT, to follow up for them. Now, I don't want to get sucked into ground one again about what difference that makes. All I want to emphasise to this court about Sunico is that this was the only way of getting the money from these defendants, first point. So it was brought as a civil claim under private law cause of action in civil courts, in circumstances where it's expressly emphasised, this is not the tax money we're going after. We're going after a quantum of damages which happens to be exactly the same sum, but our tax claim exists independently. So it's quite some steps removed from our present case. Now, I haven't got time to spend more time on the Advocate General's analysis, but you can see on that page, which is on the screen now, the heading 2, subject matter of the dispute. On the previous page, there's a heading, nature of the legal relationship. You'll see the analysis proceeds under those two limbs of what I've called the primary test. There's no new test posited. And when we get to the court's judgment, you see it on page 19, from paragraph 33 onwards, the recitation of previous cases, referring in particular to the most recent case, Sapir, Corso-Barton, TR, before applying those well-established tests, which I've sought to emphasise, a test of substance, not form. And from there on, everything that follows is simply a case of application of those principles to facts. They don't establish a new principle, as subsequent cases will show. And what Lord Punnock is doing is to seek to backwards engineer some kind of new principle from the application of the test to these facts. And my submission to others is that's a very dangerous exercise and risks losing some of the subtlety of the factual matrix before the court at this time. Looking at the application, the application of the test to the facts, at 36, you see the court recites the factual basis. In its examination of the basis of the claim, it recites the substance of the factual basis, explaining that they weren't themselves the taxed people, but that they were assisting and benefiting from the tax evasion. 37 is the single paragraph from which subsequent commentators placed so much weight, because they said, look, the legal basis is an action based not on that law, but on tort, on conspiracy to defraud, which comes under the law of tort of that member state. Well, we've seen consideration like that before, for example, in TR, but it's not determinative of the whole issue. There's nothing here to suggest that it is. 38, it continues. Likewise, it's clear that they are not subject to VAT in the UK and not liable to pay VAT under the laws of that member state. So again, looking at the substance of the matter, what is the legal relationship? It's not a tax relationship. And at 39, the commissioners aren't exercising any exceptional powers by comparison with the rules applicable to relationships between persons governed by private law. Here, for the first time, is the origin of what the judge called the use of public powers point. And the conclusion is at 40, it follows that the legal relationship between the commissioners and Sunico is not a legal relationship based on public law, in this instance, tax law, involving the exercise of powers of a public authority. And that's the point, because if under Dicey one has concluded that there is a public law relationship, in particular a revenue relationship or some other exercise of public power under Dicey, you get a different answer to the one reached here. You get the same answer as whatever answer you reached under Dicey, and Sunico should not be read as taking you in a different direction. So it's quite possible on these facts to see how well-established tests previously arrived at, if applied, could have arrived at a different answer, which is why I give you the reference paragraph 19 of my skeleton argument refers to Professor Hartley's comment that the case may be regarded as going to the very edge of what may legitimately be regarded as a civil claim, since it could be seen as an indirect way of reclaiming UK tax. And indeed, Lord Collins, you saw yesterday, a surprising result, he called it. But note that this is not the establishment of a new principle, and critically here, it was on the basis that it was entirely independent of the separate claim for tax. And cases that follow show no such change in principle. Now, my own friend Lord Paddock made a number of submissions where he drew parallels from the facts of Sunico and said, look, we arrive at the same answer. He said, look, the basis of our claim is not Danish tax law, it's background, as he put it. Now, I could go through all of those points that he made. I won't. My submission to my lords is this. The submissions he made to you were in essence a repeat of his ground one submissions. But on the footing that you arrive at a different answer, on the basis of those submissions under Dicey, then the same answers to that applies here as well. Because time and again, what it's really doing is begging the question, well, is that right? Is the basis of the claim tax law? Is the basis of the claim an exercise of sovereign power? And so forth. The very tests which would arise under Dicey, we know Lord Paddock's answer to that under Dicey, and he gives the same answer under Sunico. But these answers don't establish any fresh basis for saying if he's failed on Dicey, he somehow succeeds under Brussels. You arrive at the same answer either way. Now, Lords, the next authorities just to name check are Siemens, which is at SRA 654. That was the very next case really in the run after Sunico. It was an action to recover interest on a competition law penalty. That was held not to be a civil commercial matter. And the point is, even though that came soon afterwards, the court's focus was entirely on the substance of the matter. It was a penal context, and that was enough to dispose of the matter. Never mind it was concerning interest only, not the actual penalty. The subject matter from which it arose was a penal fine for breach of competition law. No further analysis needed, no recourse to the secondary test referred to in Sunico because not relevant. Similarly, Kuhn, SRA 656, tab 56, private law claim for bond, in respect of a bond issued by Greece, following restructuring, following the financial crisis, that was effectively given a lower nominal value, not a civil commercial claim because focus on the origins of the dispute. The origin of the dispute was the public authorities had exercised their public authority to convert the bonds by replacing them with bonds of a lower nominal value. So although it's just a claim on the debt, effectively, that was the exercise of public authority, that's the source of the dispute. This is not civil commercial. BUAC, I won't turn up, you were taken to, cites Sunico, presided over by the President, as my own friend emphasised, and it's at paragraph 48 to 49 that Sunico is cited, but it's cited for the well-established pre-existing principles, and what follows is the now conventional primary test analysis followed by secondary test analysis. The primary test looking at the legal relationship for your notice at 51 to 54 and subject matter, which was the collection of remuneration due to employees. They said that is absolutely civil commercial in nature. It's employees who haven't been paid what they are due. But then they went on to the secondary test to examine the question of whether BUAC was exercising public authority powers in any event because their ruling had some sort of special status. Our learned friend relies on that for saying, well, look, that secondary test has narrowed since Sunico. I don't accept that simply because it's not a revenue case. But in a true revenue case, the secondary test never arises anyway, because you stop at the primary test. Once you've arrived at the conclusion that it's revenue, you don't need to get on to the secondary test. Sunico was very unusual in that respect, for deciding it's not revenue, but they're having to acknowledge that public powers have been exercised, public powers have been exercised anyway. My Lords, the next case is RENA, and this is the last case I'll turn up. It's at PA 9, tab 85. This was key point for this is litigation between private parties. It was concerned compensation for the sinking of a vessel, which had led to the loss of over 1,000 lives. The principles on page 41 take a new turn in their expression, and this relates to a point my Lord the Chancellor was making to me earlier about the way the court shifts its ground and how it expresses that. It's here citing 32 to 33, a case which I haven't taken you to, called Fly LAL, but if one chases down those references, Fly LAL, if you'll notice at PA 9 at 76, at page 29, you get references back to Sunico, and you follow the paragraph number back, you go back to Apostolides, which takes you back to LTU, Rufus, Sontag, Tiad, the Surety. What they are doing here is merging the test with the Iure Gestionis versus Iure Imperii language. You see Iure Gestionis at 33, and then over the page, top of the next page, in paragraph 39 and 41, you see the references to Iure Imperii. But these are the same tests as are being applied right up to the point, but it's making it clear that they have the same scope and effect as those terms have in public international law. I haven't got time to take you to it, but you will observe in the Supreme Site case, you get the same terms, the same language again being used. And in both RENA and Supreme, you have defences being raised on the basis of public international law arguments, immunity from jurisdiction. And when you review those arguments, you will see that they are explained by reference to the, again, Iure Imperii rule, for obvious reasons, about their scope. And so what the court ends up doing, so in RENA, paragraphs 55, 56 to 58, which are all on page 44. If you look at 54, you will see the court is explicitly, 54, making clear it must be more borne in mind that the rules which constitute an expression of customary international law are binding upon the EU institutions and form part of the EU legal order. And what follows in this analysis is in effect the application of a single test, which is looking at the substance and certainly not the form of the matter. Is this Iure Imperii or not? Because that provides the answer both to whether this is a civil commercial matter or not, and to whether there's any basis for the defence of immunity from jurisdiction. You get exactly the same approach in Supreme Site, although there it's immunity from execution. I'll just give you the reference, Supreme Site at PA 1086. If you look at paragraph 63, you will see that the court arrives at a single test. And when you get to that point, relate it back to the Dicey rule and bear in mind that international law context and the fact that all of these concepts have their root in the principle of sovereign territory, territorial authority. It's absolutely unsurprising in my submission, which is completely coincides with the court's instincts on this matter, you may say, so that you end up with the same answer, the same approach under Dicey Rule 3 as you do an application of Article 1, civil commercial matter. And it also follows from that that Franson remains good law. It doesn't give way, as a judge said, simply because it's governed by the form of the action. And that, of course, explicitly holds that what is within Dicey Rule 3 as a matter of substance is outside Brussels civil commercial. So it all ends at that point. You can take it that whatever answer you reach on ground 1 reads across to ground 2. My final point, and I think it's 33 past my watch at the moment, so make it 1 minute, is about, so far as Moravich is concerned, again, like BUAC, it's the secondary test only, not in a revenue context. So again, the court found that it was blindingly obvious that powers had been made use of as a sovereign tax authority, which is unarguable. And the key point here, that's the point, as per Sunico, that displays the fact that this is a matter of substance, and for the reasons Mr. Beale elaborated, which comes back to tax. And if that is right, then all of that points this also to being outside a civil commercial action for the purposes of Brussels. My lords, I think I'm 1 minute over, but I thank you for the extra time, unless I can assist further.
Thank you.
So I'll ask you this. I'm not sure about your defendants. Your clients. I couldn't find the documents on the system. But are your clients all England and Wales based?
I think they are domiciled. Yes. My clients appear, well, I won't have found any reference to them other than at paragraph 194 to 195 of the judgment, where they make clear that they are the relevant beneficial owners entitled to dividend payments and so sufficient to be able to claim to have had dividend tax withheld by operation. So the point is, I didn't mention that. The point is, your panel puts this point on, you have to assume everything in our direction. You have to assume that this is fraud. But they are sued for a number of causes of action, not just fraud, but non-fraud causes of action as well, all of which must fall away on Lord Pannick's approach, other than a summarisation of fraud.
I understand the point. My concern is that some of the respondents may be EU-based. Certainly some I've seen are Luxembourg, some are Germany. How can they take point that this is not a civil or commercial matter?
The answer to whether it's a civil commercial matter doesn't. Obviously, how, in terms of the effective jurisdiction, for the.
Presumably, they were served with the convention, weren't they?
Yeah, they may have missed the opportunity to take that plea. I don't know. I wasn't involved below, and I don't know what led to that, and whether they've submitted to this jurisdiction or not. Again, I don't know. But
it matters for our decision, doesn't it?
Well, I mean, I would say that there is no. Well, I'm not going to go further than say my analysis depends entirely on the outcome of the Dicey Rule 3 point, and that if
that would leave us in rather a difficult position, wouldn't it? If some of the respondents are bound by the jurisdiction, not having challenged it.
Well, either this is a Dicey Rule 3 point or it isn't. If it is, there's nothing to proceed against them in this jurisdiction at all. If it isn't, then it is also a civil commercial claim for Brussels purposes, and the matter proceeds on that basis. So I don't think I can do better than that.
Well, I think we feel there may be a problem there that hasn't really been grappled with. But maybe it's not for you. I don't think.
No,
I think your clients certainly look as if they're based in the UK.
Well, we didn't actually have an answer to that, but
The names would suggest that they were, but it doesn't mean that they are.
Well, my instructions are that some of the clients are UK based, some are US based. That's what I.
Some of them, I was about to say they might be US based, but they're not EU other than UK, if that makes.
That's our understanding.
Yeah. So Mr. Palmer is not the right person to answer the question.
No, I hope not. The 3 of my clients are domiciled. The 4th was at the time he was served, I understand, but is no longer That's what I've just been told.
Okay. Thank you very much, Mr. Palmer. Apart from that, we're... Yes. Panic.
My Lords, can I go back to ground one first of all?
Yeah.
And in my submission, it is important to distinguish between the respondents' reliance on the revenue rule and their reliance on a broader umbasogo public law principle of sovereign powers, because the criteria for each of them are different. Can I deal first with the revenue rule? There are, as we see it, two issues here for the court to decide. First issue is what is the scope of the revenue rule, and secondly, does the rule apply in the circumstances of the present case? On that first issue, we say that the scope of the revenue rule is very clearly established by the case law to which I took the court in opening. The revenue rule only applies if this is a claim directly or indirectly to recover tax due. The challenge to that proposition of law came from Ms. MacDonald, and she said that Lord Mackay's speech in those terms in Williams and Humbert should be understood as applying only where the claim is brought by the state itself. We say there are a number of difficulties in that submission. Could I take the court back, please, to Williams and Humbert? It was Principal Authorities, Volume 1, at tab number 5, and the relevant passage in the speech of Lord Mackay speaking for the House is at page 73 of the electronic bundle, page 440. And Lord Mackay expresses himself generally without the qualification suggested by my friend Ms. MacDonald. But more than that, Lord Mackay says at letter H on page 73, there is a rule of law which precludes a state from suing in another state for taxes due under the law of the first state. So Lord Mackay expresses the rule by reference to an action by the state. Although I take my friend's point, this was not a case brought by a state, but that's the rule. And over the page 74, as was pointed out to Ms. MacDonald, at the end of the first paragraph, between A and B, his lordship referred to this as an essential feature. And of course, what Lord Mackay was doing...
Well, Buchanan was a case, wasn't it, where the claim was brought by the liquidator?
Yes.
So it wasn't brought by the state at all?
No. No. But nevertheless, that's...
So the argument falls down just on the face of the judgment straight away.
Well, the statement of principle by Lord Mackay, I say, is very clear indeed. And indeed, what Lord Mackay is doing is explaining his understanding for the appellate committee of the principle in Government of India and Taylor. That's the case he discusses at the bottom of page 73 with others. And of course, there's also, in my submission, of course, there's no reason why what Lord Mackay considered to be, quote, essential, unquote, should only be essential in some cases.
Did we get the negatives in the wrong place? What you said was Mr. MacDonald said that Lord Mackay's speech in those terms in should be understood as applying only where the claim is brought by the state itself.
That was the submission as I understood it. But Ms. MacDonald recognises that Lord Mackay's speech states that the principle in Government of India and Taylor is a principle which applies only where the claim is for taxes due. That's what he says. And my friend, Ms MacDonald, says, well, that may be the principle that applies when the action is brought by the state, but it's not the principle which applies in other cases. I think that was the submission. But in any event, my submission is there's a clear statement of principle as to the scope of the revenue rule. The rule applies if and only if it is a claim for taxes due.
Exactly what you say.
And in my
The extra
submission,
layer of analysis falls away when you look at a claim by the sovereign himself.
and he says it a number of times. I add one point on this. Because the revenue rule is absolute, if the claim is for taxes due, there's no public policy defence, unlike the sovereign powers principle. We do submit that it is important not to expand the scope of the revenue rule beyond established authorities. I turn then to the question of whether this claim, a claim by my clients, is a claim for taxes due. Does it fall within the revenue rule? And our submission, as the court knows, is that the claim which we are bringing in this court is not a claim to recover taxes which are due in Denmark. We say that where a revenue authority brings a claim to recover the value of a refund paid to a person who had no entitlement to it, on our case, indeed a person who's not paid any tax, on our case, and indeed, on our case, a person who had no tax relationship with the tax authority prior to the refund application. And all the more so when the case is that the application was fraudulent. We say it would defy language common sense principle to categorise such a claim as a claim for tax due. There is no tax due, there never has been, on our case. My friend Mr. Beale made forensic use of correspondence, particular correspondence with AccuPay, which the court had at Supplementary Bundle 1, tabs 1 to 3. And the court has seen that SCAT suggested that it had a claim to recover the overpayments pursuant to the tax legislation. The answers to that point are as follows. First of all, although letters were written threatening action under tax law, Mr. Beale accepted, rightly accepted, that there were no tax proceedings commenced to recover overpayments. Letters were written, no doubt because SCAT was understandably concerned to explore every possibility of remedying the mischief which had occurred. And the Danish Hansard passage to which Mr. Beale referred, it was SB 1/4/1, evidences, undoubtedly evidences that concern. But no proceedings were brought to recover the overpayments. Secondly, the reason why no tax proceedings were commenced to recover overpayments was because SCAT recognised that it had no power to do so. There is no statutory provision, there's no judicial authority which confers power on SCAT to recover the overpayments as a tax debt. or indeed, to put it more broadly, pursuant to the tax legislation. All that SCAT can do is proceed by way of a normal civil claim to recover damages for fraud, or proceeds of fraud. Mr. Beale took the court to the relevant legislation. I simply say that none of the provisions of the Withholding Tax Act confers any right to recover overpayments. And indeed, to be fair, nor did Mr. Beale so suggest. This issue is expressly addressed in the pleadings. And can I invite the court's attention, please, to the supplementary bundle SB1 at tab number 15. And your lordships will find there our SCAT's re-amended reply to the defence of Mr. Knott and Mr. Hoogerworth. The reason it's there is because they'd raised this point. And if your lordships please return to page 3 of the electronic bundle, your lordships will see at the top that we are addressing Dicey Rule 3, and the relevant part of it is at letter B in the middle of the page. And B says it is denied, if alleged, that SCAT's claims seek to enforce the revenue laws of Denmark. In particular, first of all, we say there's no unpaid tax or unsatisfied tax debt. But secondly, Roman 2, SCAT is not entitled under Danish law to issue a tax assessment to those defendants, or for the avoidance of doubt, any other defendant or the withholding tax applicants, or make any other public law decision obliging them under Danish revenue or public law to pay the sums sought in these proceedings. And it's not merely the fact that we have so pleaded. This court has been shown no provision which would entitle SCAT to bring tax proceedings to recover the overpayment. I also mention, although I don't found my submissions on this, but I do also mention this was not the basis on which the judge below decided the case. See paragraph 103. And I also mention, although I'm not seeking, of course, to shut out arguments, but I do mention that there is in fact no respondent's notice on this point. Mr. Beale then referred to the US-Denmark double tax agreement. What Mr. Beale did not address was what I showed the court in opening on Tuesday, what Judge Lewis A. Kaplan had said about this in the United States District Court. And can I go back to it, please? It's in PA 7, Principal Authority 7, at tab number 57. This is the judgment of Lewis A. Kaplan in the US Federal Court, District Court. And the judge dealt with this matter at pages 27, yes, page 27 in the electronic bundle. And it's the final paragraph before the footnotes where he refers to the US-Denmark Treaty and its provisions for assistance in the collection of a revenue claim. And he says they're irrelevant because the plaintiff's claims do not seek to collect tax owed by the defendants and covered by this treaty. The Danish taxes that make up a revenue claim include the following, and one of them is income tax. And then he says, I'm sorry, well, over the page, yes, page 28. One of them is certainly income tax. I take no issue on the character of the tax. But at the end of that first paragraph, the judge asserts money obtained by fraud from SCAT is none of these things, and we respectfully agree. In any event, there's nothing in the US-Denmark agreement. Mr. Beale took the court through what he said were relevant provisions. There's nothing in it which addresses the recovery of overpayments of refunds, far less those obtained by fraud. Mr. Beale drew specific attention to Articles 10 and 22. Neither of them address this subject, and in fact both of those provisions, Articles 10 and 22, have been replaced by the 2006 protocol. And just so that the court has the correct reference, it's in SRA 7, tab 60, and the protocol begins at page 36, and the relevant provisions are at 37 and 42. They're not the provisions that Mr. Beale drew attention to. They were replaced by the protocol some years ago. So I say none of this assists the respondents. Mr. Beale then drew attention to the article by Lord Collins in the LQR on the Sunico case, in which Lord Collins, and this, I don't invite the court to turn it up, but it was SRA, Supplementary Respondents Authorities, Volume 7, tab 68. The court will recall Lord Collins' criticism of the Sunico case and the contention by Lord Collins, who knows a thing or two, that Sunico would have been decided differently under Dicey Rule 3.1. And the reason why Lord Collins so asserted was because in Sunico there was an outstanding VAT tax liability, which in the opinion of Lord Collins, the claim was indirectly seeking to recover. And I'll come back to this when I get to ground 2. My point is that none of this Lord Collins' criticism assists Mr. Beale in a case such as this, where there is no existing tax debt and never has been. Similarly, the case of HMRC and Ben Nevis, to which Mr. Beale drew attention, SRA 3, tab 27, again was a case where tax was due. And the same is true of the United States Federal Court of Appeals cases to which Mr. Beale drew attention. The cases were R.J. Reynolds, SRA 5, stroke 45, and the Honduras case against Philip Morris, SRA 5, stroke 46. Again, they concerned unpaid tax debts. A point was made by Mr. Beale, and indeed also by Mr. Jones in opening submissions for the respondents, that fraud cannot provide the answer under Dicey Rule 3.1. Can I seek to be clear on what we say is the relevance of fraud in these proceedings? First of all, I accept that if this were to be a claim for the recovery of tax due, then a plea of fraud would not assist SCAT. And I accepted that in opening this appeal, and I drew attention to Buckingham, which is such a case. One does not need US authorities for that proposition. But second, a plea of fraud is relevant to the question whether this is a claim to recover tax due. We seek to establish at trial that the respondents do not have and never did have any liability in tax. To help establish that point, we will seek to show at trial that there were no relevant shares, no dividends, no tax withheld, and that there were fraudulent representations to the contrary. So there's an evidential relevance, we say highly material relevance, of fraud. Third, the plea of fraud is also relevant in relation to the respondent's argument that this is a claim in the exercise of sovereign powers. Our contention, and I'm coming to this part of ground one, our contention is that the claim in these proceedings is not an exercise of sovereign powers. It's a claim by a victim of fraud to recover the proceeds or damages, a claim that could be brought by a private person who is the victim of fraud. Part of our answer, an important part of our answer to the sovereign powers argument is that the respondents seek to ignore the fact that the refund payments were made and only made because of the fraudulent representations, a point that your lordships put to my friends. And the fourth point on the relevance of fraud is that it's also relevant because the sovereign powers principle, by contrast with the revenue rule, recognises a public policy exception. And I say, I made the point in opening, there is a strong public policy that the respondents cannot be allowed to avoid liability for their fraud.
Could you, if only for my benefit, not panic, your submission a moment ago, part of our answer, an important part of our answer to the sovereign powers argument, is that the respondents seek to ignore the fact that the refund payments were made and only made because of fraudulent misrepresentations. I've got that. But how exactly does that work? How does that feed through to become relevant? I mean, instinctively, one can say fraud, it's all written water. But what is the technical explanation for how the fact that they're induced by fraud is material?
Because, as I think it was your lordship put to me or one of my friends earlier this week, if the repayments were made induced by fraud, they have no validity, they are a nullity. And it is therefore impossible for my friends to, many reasons why they can't rely on the repayments, but one of the reasons, and I'm coming to all of them, one of the reasons is that they are seeking to rely on an act, the act of payment, which was induced by fraud. And if we are able to sustain that contention at trial, then either the act of payment was a nullity, or, and it may make no difference, the respondents cannot be allowed to rely on their own wrong for these purposes. That's how we put it.
I think this is, forgive me, I think this is going rather further there than I think I understood the point to go, because I quite see that if you fraudulently obtain a payment when there wasn't any tax or any tax paid at all, but obtaining a refund of tax which was paid by fraud seems to me to be a different kettle of fish altogether.
Well, your lordship may well be right about that. It's not this case on our pleaded.
No, but I'm not sure you get as far as to say that the fact that you obtain a tax refund by fraud would mean that you're then outside the revenue?
Well, I'm not dealing, my lord, to be very clear, I'm not dealing with the revenue rule. And the example that your lordship gives may be a case that falls within the revenue rule, because there was tax due.
And this is the wider,
Yes. Yes.
principle,
Yes.
wider.
I'm addressing
Aspect
the
you're
issues
addressing.
on the premise that we are correct in submitting that this is not a case within the revenue rule.
But within the wider, it's not within the revenue rule, but it's on the hypothesis it's within the Sovereign Act,
Yes. Yes.
which itself is a slightly difficult line to tread, I thought.
The whole area is difficult to tread because in the tax context, the law has proceeded by reference to the revenue rule. And my friends are seeking to apply the umbasogo principle, which one can well understand in the context of an action for damages for the consequences of a coup d'etat, to a context that is fraud on the tax system, which in our submission is best addressed, sensibly addressed, pursuant to the revenue rule. And the only reason why my friends have emphasised in this appeal, that it was certainly part of the hearing below, but they've emphasised it in this appeal, is because their case under the revenue rule, in my submission, is very weak, if not non-existent. So that's the difficulty that we face. But treating the sovereign powers claim on its merits, I need only go so far as to say, in a context where there is no tax relationship, there's no tax due, there's never been any tax withheld, it is impossible to see in my submission how it could be right that the defendants can rely on the fact of payment out induced by fraud. That's my answer to my lord's question.
Yes, thank you. I think I had not been sufficiently distinguishing between the revenue rule and the sovereign power. Partly induced, if I can use that word, by the fact that the respondents tend to say this is a claim for revenue and therefore it's a sovereign act and run it together.
Well, that's why I began my submissions in reply in respectfully suggesting to the court that it is very important to be clear about the nature of the principle that one is addressing. They are not the same principles, although plainly there is a relationship between them, but they are distinct principles. And the umbasogo principle is a principle that has been developed in a case where one is not addressing a revenue law or a penal law. One is addressing an other public law. And I have no quarrel with the umbasogo principle.
And the other point, which was the point we did put to, I think, some of the respondents' counsel, I can't remember which, yesterday, is you know, one has to focus on what the rule is.
Yes.
I mean, whether it's the narrow revenue rule or
Yes.
the wider public
Indeed.
law rule.
Indeed.
English courts have no jurisdiction to entertain an action for the enforcement, either directly or indirectly.
Well, your lordship's absolute, that is
so
crucial.
The point about, I mean, if you're right that there's no tax here, so there's no outstanding tax here, and if you're right about what Lord Mackay said in Williams and Humbert, defining the scope of the revenue rule, so that this case falls outside the revenue rule for that reason, because there never was any tax due in relation to these respondents, then the only basis on which they can say that this is inadmissible in this court is on the public law
Yes.
aspect. But what one's focusing on is the nature of the action.
It's the nature of the claim.
And the American cases which you showed us, those two New York state cases, make the point, don't they? What was being done there was not a sovereign, not an attempt to effectively to uphold a sovereign power. It was simply the recovery of damages for by somebody who was aggrieved,
Yes.
as they say.
Indeed. So one's got to be very, very clear about the nature of the point, whether it's a revenue rule or something wider.
So the nature of the I mean, they might be right that in paying out the money. I mean, I follow your point about whether it's invalid or void or whatever. They might be right that in one sense that's the act of a sovereign authority, but because it was on your case void or invalid because of the fraud, you have to focus on the nature of the action before this court.
Precisely so. Can I deal with it in stages, very briefly, but in stages, this broader sovereign powers argument? And I preface this by pointing out there is no authority in any context comparable to this one where a broader sovereign powers argument has been recognised. That is in a tax context. The cases deal with the matter, either you're within the revenue rule or the case can proceed. But let me deal with the merits of what is argued. Mr. Beale emphasised that Denmark had made a number of sovereign decisions. It had chosen, he said, to tax dividends paid by Danish companies. It had chosen to charge a 27% tax on those dividends. And it had chosen to withhold tax at source. All true, but they were not sovereign powers exercised at all as against these respondents who had no relevant shares, received no dividends, had no tax withheld on our case. And the court is not concerned in the abstract with whether there are sovereign exercises of power which are part of the context of the claim. The issue, as my Lord the Chancellor just put to me, the issue is whether this claim is an exercise of sovereign power. And there are two authorities that establish that that is the test. The first of them is Umbasogo. It was Principal Authorities, Volume 3, tab number 22. And it was the paragraph that your Lordships discussed with my friend Miss MacDonald, paragraph 50, which is on page 28. And at line 3 of paragraph 50, the Court of Appeal say the critical question is whether in bringing a claim, a claimant is doing an act which is of a sovereign character or which is done by virtue of sovereign authority, and whether the claim involves the exercise or assertion of a sovereign right. That's the question, says the Court of Appeal. And the Court of Appeal returned to that in the Iran case, which was at Principal Authorities, Volume 4, tab 25, page 36, PA4, tab 25, page 36, where helpfully, in the third line, the Court of Appeal summarises what it understands to be the ratio of the Umbasogo case. The third line, although the court approved the residual category of other public law, the ratio is that a claim involving the exercise or assertion of a sovereign right is not justiciable. And the focus on the claim is of vital importance because of the basic principle of this area of the law, which is, as my Lord the Chancellor put to me a few moments ago, that while the court will not enforce a revenue or a penal or a public law, it will be prepared to recognise such a law. And either yesterday or maybe this morning, I think yesterday, my Lord Justice Phillips asked about this distinction between enforcement and recognition. And it's, I say, a very well-established distinction. The judge accepted it. He said it was agreed between the parties paragraph 17, Roman 6 of the judgment. Let me show your lordships the authority. It's set out in Dicey, PA 11 at tab 105, Dicey, Morrison, Collins, and the learned authors deal with this on page number 5. And they deal with it under paragraph 5-023. The last 4 lines, the last 5 lines of that, your lordship see in 5-023. Rule 3.1 relates only to enforcement, but it does not prevent recognition of a foreign law of the type in question. They say it's sometimes difficult to draw the line between an issue involving merely recognition and indirect enforcement of it. Then they say where direct or indirect enforcement does not arise, a foreign law of a type falling within Rule 3.1 will be recognised if it's relevant to the issue and provided it's not contrary to public policy. So that's the principle of law. And it's a very old principle. It can be traced back a long way, but it was recognised by Lord Keith in government.
Can we just drop that page down and see what the references are in the footnotes?
Yes. If we go down to the footnotes, your lordships will see that Ortiz, I think, is
yes,
mentioned.
Regazzoni and Sethi, that's where I was.
Yes, indeed. So there's a number, and I haven't taken your lordships to those. If your lordships wants other authority, the court will find it in the Government of India and Taylor, PA1, tab 4. Lord Keith deals with this on page 20 of the electronic bundle, where his lordship refers to the Buchanan case.
Yeah.
And in the opening part of page 20, there's a reference to Buchanan and McVeigh, and then leaving out 4 lines, it illustrates 2 propositions. That there are circumstances in which the courts will have regard to the revenue laws of another country. In no circumstances will the courts directly or indirectly enforce the revenue laws of another country. So there's nothing wrong, there's no inhibition under Dicey Rule 3.1 in the court having regard to the Danish revenue law, to the Danish revenue system. Question is whether this claim is a claim directly or indirectly to enforce, or is a claim under the sovereign powers, a claim to exercise sovereign powers in this country. And Ms. MacDonald and Mr. Zellick developed submissions that the decision to pay the refunds is the sovereign act. That, of course, is not to focus on this claim, it's one stage back, but in any event, it's a very difficult submission, I say, for a number of reasons. The first of them is that the decision to pay out was the result of the fraudulent representations. I've made that point. We say that the decisions to pay out therefore have no validity. The respondents cannot seek to take advantage of their own wrong. But secondly, in any event, we're not seeking by this claim to vindicate the payments out, to vindicate the decision to pay out. On the contrary, we are seeking to establish that those decisions have no effect and that we are entitled to damages because we were defrauded. We're not relying on those decisions in the sense of vindicating them. Thirdly, Ms. MacDonald and Mr. Zellick have to say, although they didn't address the case, that the appellate division of the New York Supreme Court was wrong to recognise that a claim to recover an overpayment is not an assertion of sovereign authority. That was the Rosenthal case, Nordrhein, Westphalen and Rosenthal, which I won't go back to. The court recalls it. It was Principal Authorities 7, tab 48. And they also have to disavow, my submission, the approach taken by Dr. Francis Mann, which was approved by the Court of Appeal in Umbasogo at paragraphs 42 to 43. Again, I won't go back to it, given the time, but it was Principal Authorities, Volume 3, tab 22, pages 25 to 26. And Dr. Mann's thesis, the court recalls, is that there's an important distinction between a claim by way of sovereign authority and a claim to a remedy for a wrong which might be suffered by a private person. And we are seeking a remedy to recover sums paid out by reason of fraud, as would a private person. My Lord Justice Stuart-Smith asked yesterday, what is a patrimonial claim, the concept to which Lord Keith referred in Government of India and Taylor. The best I can do is to show the court, and I've got copies for my friends to give them. If I could ask the assistance of the usher, thank you very much, of Black's Law Dictionary. Thank you very much. Another one there. Edited by the estimable Mr. Garner. And the court will see on the right-hand side of this document when it reaches the court, on the right-hand side, 5 entries down, there's a definition of patrimony. And the second definition of patrimony says civil law, all of a person's assets and liabilities that are capable of monetary valuation and subject to execution for a creditor's benefit. In other words, it's a person's property, broadly understood.
Very broadly understood.
Very broadly. Very broadly understood. And I say, very, very basic terms, in this case, on our case, part of the property, part of the assets of SCAT were misappropriated. They were taken from us by fraud, and we are seeking their return or compensation damages for that wrong, as would a private person. That's what this case is really all about.
I thought that an aspect of patrimony note here was that referring to the personal power of a ruler rather than the sovereign power.
Well, the phrase comes from Lord Keith, who distinguishes between sovereign authority and what he describes as patrimony. And in my submission, the point he's making is that there is a distinction later drawn by Dr. Mann, between exercises of power of a public nature and dealings with assets in the way that a private person would deal with them for the purposes of a claim. And I say, just as a private person who is defrauded of their assets is entitled to a remedy, so is SCAT. That's how I put it. There's a further difficulty, I say, with Miss MacDonald's argument, and it is the fact that my friend, under questioning from your lordships, and understandably was unable to provide any sensible distinction between this case and the cases put to her by the court. The judge recognised it's very difficult to see why SCAT could not seek to recover the payments, to recover a payment of a refund made to Mr. A in the belief that he was Mr. B. My Lord Justice Phillips put that to my friend. All the more so if it's not just the fact that the technical operator at SCAT puts in the wrong digit for the bank account, but if it's induced by a misrepresentation or indeed a fraudulent misrepresentation. that is as much an exercise of sovereign authority making that payment as the payment in this case. Or another example my Lord Justice Phillips gave, where the recipient of the refund has bribed the official and a payment has been made under the statutory scheme. One can imagine, if necessary, more extreme examples, that the official has a gun put to their head or to the head of their family. And my friend Miss MacDonald's only answer could be that in such a case, the act of payment out is vitiated by the mistake or by the bribe or by the threat. But then I say, equally so, if the payment out is the result of a misrepresentation, all the more so a fraudulent misrepresentation.
Is that a convenient moment to have a short break?
Yes, I've forgotten the time. Yes, ma'am, I won't be much longer. Thank you.
Court rise.
Given out for free when we were in lockdown. I got an umbrella, some masks. Good wishes.
You'd like snooker players, a few things on your
Yeah, that's right.
sleeve and that sort of thing.
Offer parts of my silver jacket for branding for clients.
Is it?
Do you have a Blackstone tattoo or something? No.
Oh, no. That's getting personal.
Yeah. I'll show you mine. Nice to show you yours. Sure you haven't got.
You don't have a black
Someone likes to tattoo. It's more brand. Well, luckily I go to the hardware quite a lot, otherwise I would be in deep trouble when we moved on. I don't think anyone's found it.
Court rise.
Lords, completing ground one, my friend Mr. Zellick then submitted that the true characterisation of Scott's claim is that it's an allegation of conspiracy to defraud. Sorry, Lord.
Don't worry.
But it's still not a claim to recover tax due, and therefore the revenue rule doesn't apply. It's not a claim which seeks to enforce Danish tax law, although I accept the court is being asked to recognise Danish tax law. And even if, contrary to our submissions, this were a case of exercise of sovereign authority, there is a public policy exception.
Yeah.
See the Iran case. I won't ask the court to go back to it, but it was Principal Authorities 4, tab 25, page 42, paragraphs 151 and 154, and Dicey, Morris and Collins, Principal Authorities 11, tab 105, page 15, at paragraph 5-040. And for the reasons I gave in opening, I say to shut out a claim that these respondents have defrauded SCAT would be contrary to public policy. It would encourage fraudsters to think that foreign public authorities are attractive targets for their activities.
Yep.
One final point on ground one. Mr. Jones, in his submissions, emphasised that a determination on ground one in our favour would not be dispositive because the facts may turn out to be different to those pleaded by us. And that's self-evidently true. I simply point out that it was not our idea to have a revenue rule preliminary issue. Indeed, it was opposed by Mr. Feely for SCAT, as Mr. Jones recognises in his skeleton argument. We're in your lordship's court because the respondents persuaded the judge below to strike out this claim on the basis that the revenue rule does apply. We say the reasoning of the judge, with great respect, is unsustainable and there's no basis for applying Dicey Rule 3.1. Unless there are further matters I can address on that, can I turn to ground 2? My friend Mr. Malik and my friend Mr. Palmer each submitted that if this is a revenue matter for the purposes of Dicey Rule 3.1, as is not disputed in the case of ED&F Man, it must be a revenue matter for the purposes of Article 1 of the regulation. And my answer to that is that the criteria are not the same. And that is shown by Sunico and by Lord Collins' comments, because the whole thrust of the comments of Lord Collins were that the facts of Sunico would fall within Dicey Rule 3.1 because this was an indirect attempt by the revenue authorities to recover tax due. And therefore, it cannot be the case that Dicey Rule 3.1 and Article 1 are exactly the same. As my friend Mr. Palmer recognised, our case is based on two decisions, Sunico and Sapir. Sapir being the case about the claim for overpayments, and Sunico, the claim by HMRC. We rely on those judgments not as matters of form. We say they are decisions of substance. We have no quarrel with much of what my friend submitted in relation to the criteria to be applied by the Court of Justice in relation to Article 1. But what he can't get away from is that the Court of Justice made the decisions that it did make in Sunico and Sapir. We say they adopted and applied the conventional criteria, and there are no later cases in which the Court of Justice has dissociated itself in any way from those judgments. I appreciate that my friend argued they don't help us on their merits, but they cannot be dismissed as some sort of maverick cases. What they do is they illustrate how the principles of EU law as to civil and commercial are applied in circumstances, we say, analogous to the circumstances of this case. On Sapir, which I won't take the court back to it, but the court has it at Supplementary Appellants Authorities, Volume 2, Tab 12. My friend Mr. Palmer said that the case is explained by the fact that a public authority owner of land was in the same position as a private owner of land. And that's an important part of the judgment, says my friend, and we understand why he says that. Our point is that here Scat is in the same position as any other victim of a fraud. It is entitled to bring its claim by civil proceedings to recover that of which it has been defrauded. In our submission, an overpayment, a claim for an overpayment in those circumstances is not regarded by the Court of Justice as other than a civil and commercial claim. Sunico, which your lordships have seen in at least twice in Principal Authorities Volume 9, Tab 77. I will not repeat my submissions, the court has them, as to why we say that the Sunico case, although not on all fours with the circumstances of this case, is closely enough analogous to establish that where a tax authority is seeking to recover sums of money as that are the consequence of a fraud, that is a civil and commercial matter, even if, in that case, there was a close correlation between the sums being claimed and the tax due which had not been paid. This is a much stronger case because there is no tax due. In that case, there was. And my friend Mr. Palmer's attempts to distinguish the Sunico case are very difficult to reconcile with Lord Collins' criticisms of Sunico for not following the approach in Dicey Rule 3.1 when there is a sum tax due which is indirectly being sought. Mr. Palmer challenged the judge's conclusion of paragraph 174 on the use of information. I made detailed submissions on that in opening by reference to Buak and Movich, and I won't repeat them. If this case does fall within Article 1 of the regulation, then the second issue is preclusion, which was addressed by my friend Mr. Malik. And Mr. Malik's submission, I hope I summarise it fairly, is that the regulation is concerned with jurisdiction, and Rule 3.1 is not a rule of jurisdiction. It is a substantive rule of law. The difficulty in my submission with that argument is that the case law shows that the Brussels rules on jurisdiction may have an effect on English law rules which are not rules of jurisdiction, but which are rules of public policy as to admissibility. And I took the court in my opening submissions, in particular, to Lucasfilm, and I drew attention to the Mozambique rule, which is a rule of English law public policy, which said the courts, both the Supreme Court and earlier this court in the Pierce case, was a rule that could not be applied by reason of the contents of the jurisdictional rules in the Brussels regulation. I won't return to that, but what I do wish to go back to, if I may, is Lucasfilm at PA4, tab 27, at the end of the judgment of Lord Walker and Lord Collins, page 37. And I do so because my friend, Mr. Malik, submitted that it is unarguable that important rules of public policy of English law which go to justiciability can be overturned by reference to the Brussels regulation. And the point that I made in opening, and to which I draw attention again at page 37, is paragraph 112, where that is precisely what Lord Walker and Lord Collins for the Supreme Court recognise is a difficult question of law, a question, as they say at 113, on which a reference to the European Court might be required. And they reach that conclusion in the specific context at D on that page of the the Act of State rule in Boots, Gas and Hammer, which is, on any view, a fundamental rule of English public policy, which is a rule of justiciability. Now, they don't decide that such a rule is inapplicable by reason of the regulation, but they recognise that this is a real issue which needs to be addressed in an appropriate case, need to determine it there. So I cannot accept, with great respect to my friend, that this is an argument which is untenable, which does not have a proper, respectable legal basis. Of course, it is necessary for us to show that to apply the domestic rule would cut across, would inhibit the application of European rules. But that was the subject of my submissions in opening, that when one looks at the jurisprudence of the Court of Justice, it is addressing factors very similar to those which the courts look at in relation to Dicey Rule 3.1. And indeed, Mr. Palmer's submission was precisely to that effect, that Dicey Rule 3.1 and Article 1 must be read in the same way. If, therefore, if the court were to accept we are within the scope of Regulation 1, I do maintain the position that it would be contrary to the regulation for the domestic court to apply its own rules on this issue. Mr. Malik referred to the Court of Appeal's judgment in Lucasfilm. That judgment in my submission has limited value for two reasons. First, because of what the Supreme Court said in the passage I've just shown this court, and second, because the case, the Lucasfilm case, was concerned with whether, and if so, to what extent, the jurisdictional rules apply to cases raising issues outside the EU. That appears at paragraphs 105, 116 and 119. The reference is SRA 3, tab 25, pages 32 to 33. My Lords, everything else I think would be repetition of what your Lordships have already heard from me, and I don't want to do that. I'm very happy to seek to answer any other questions the court may have, but those are the submissions I wanted to make on behalf of SCAT.
Thank you very much.
Thank you very much, my Lords.
Thank you. Well done for finishing within time. Well, contrary to what was suggested, I hope, in jest at one point yesterday, we are not going to deliver an extemporary judgment on return at 3:45 on a Thursday after what has been an extremely interesting and difficult case. Thank you to all of you and all your teams for the way in which the case has been presented. Thank you also for all the arrangements that have been made by Opus 2 in relation to the presentation of the case, which has gone about as well as it possibly could do, certainly in the courtroom. I hope that those who participated remotely have had a similarly happy experience as we have. We will reserve our judgment. No promises as to when you'll get it, but we'll do our best to do it as soon as we possibly can. You'll get it in the usual way for typographical corrections, not for inviting the court to reconsider it by making further submissions. And if you, despite the large number of you there are, if you could try to agree a form of order, so it's not necessary to have a further hearing. If matters can't be agreed, we'll try to deal with them on paper. But thank you all very much again.
Thank you, Lords.
Court rise.